seated. Good morning. Welcome. We have, depending on how you count them, either 4 or 5 cases on the calendar this morning, which we will take in the order in which they're listed. After the first or the first 2 cases, again, depending on how you count them, we're going to take a break, at which time we invite all of you to join us for coffee in the Commons, which is through those doors to your right. Okay, the first 2 cases are Hines versus State and Hines versus State. We've allotted 15 minutes to decide, and Mr. Uferman, that's for the 2 cases combined. I'm sure you know that. And before you start, let me say that I hope everyone has had explained to their satisfaction the functioning of the clock, because it's sort of a mystery to me. But the time that you see remaining on the clock is the time you have remaining. If you're the appellant, that's your total remaining time. So if you want to reserve some time for rebuttal, you need to take that out in your own mind of the total remaining time. Okay, Mr. Uferman.
May it please the Court. Michael Ufferman, on behalf of the appellant, Freddrick Hines, I'd like to reserve 5 minutes of my time for rebuttal. I intend to be brief this morning. Mr. Hines had a 3rd case pending before the Court involving an issue that is identical to the primary issue raised in both of the cases before the Court today. In March, a panel of this Court...
Well, it's really not identical to the issue in 294, is it? Because there was a previous acquittal in the case that's already been decided, and in 294 there was a subsequent acquittal.
Correct. So I would submit that factually they're indistinguishable. Procedurally, 294 is a little different.
Well, you don't think that has any impact?
No, and I'll jump right into that.
Well, let me ask you then, if he had been charged with both of these crimes in the same trial, and the jury went out and convicted him of robbery, and then the jury was brought back in and they gave him the testimony about possession of the firearm by a convicted felon, and they said no, not guilty of that, would the trial judge then have to enter a not guilty verdict on the first conviction?
I think I would argue that these cases could not be tried together in the same trial. I would argue that the
Well, then give me a factual situation. I mean, there's obviously a factual situation where defendants are convicted at trial and the jury's verdict is inconsistent. Does that mean that they have to be acquitted on everything?
Well, yes. As far as if the state had attempted to try the March 21st possession of a firearm with either the March 13th, the March 15th, or the March 3rd robberies, I would hope the defense counsel would move to sever and say they're separate incidents and can't be tried together. There's
no other case where the conviction occurred subsequently, is there?
Sure. Oh, yes.
Burr is one, isn't it?
Burr, and then Perez is the other. And Burr was a death penalty case where the issue, the collateral crime evidence came in during the penalty phase.
Well, it came in during both phases, actually.
That's right. They found it harmless as to the guilt phase, but it came in during the penalty phase, and the Florida Supreme Court affirmed on direct appeal. The issue was raised in a Rule 3.850 motion, and in Burr, the Florida Supreme Court said a couple things. Number one, that they said the previous decision in Perkins was a state constitutional principle, a due process principle, that when a particular event or element has previously been considered by a jury and there's been an acquittal, the state can't rely upon that for any other trial.
Now, Perkins was a previous acquittal, though, wasn't it?
Correct. Perkins was.
But they said in Burr the same rationale applies to a subsequent acquittal under Florida law.
That's exactly right. Burr applied Perkins even though the acquittal in Burr occurred after the trial and was brought up during a post-conviction proceeding. Perez is procedurally indistinguishable from this case because in Perez, the collateral crime evidence was relied upon by the state at trial, and subsequent to the trial, there was an acquittal, and then the defendant brought that to the appellate court's attention while the case was still pending on direct appeal, and the 4th DCA reversed.
Is there any distinction at all between evidence and conduct? I mean, what is it that we're trying to protect the defendant from? Isn't it his conduct?
Before I answer that question, I think that's somewhat reaching into what the March panel has already decided. I think the March panel has decided that whatever you label this, whether it's collateral evidence, conduct, an event, that in this circumstance, the fact that the jury determined that on March 21st, Mr. Hines did not possess that firearm that was found in the grill, and that acquittal prevents the state from relying upon that evidence in the robbery, in that case of the March 3rd robbery. In these two cases, it would be the March 13th robbery and the March 15th robbery. The March 2008 Hines case decided that issue. I think there is obviously, I reviewed that oral argument. I know that you were on that panel, Judge. There was some questions asked about how does the rule apply? How does the Perkins rule apply? And you look at the issue that was determined by the jury, and that particular issue, if there's an acquittal, can't then be relied upon by the state in any other proceeding, whether that proceeding is before or after the acquittal. So in this case, the state was arguing in both of my cases that are pending before the court today, arguing that Mr. Hines possessed that firearm on March 21st. And oh, by the way, that firearm was either the same or very similar to the firearm that we think was used in these two robberies. They actually showed a picture of that exhibit that was obtained on March 21st to the victims, and the victim said, yeah, that's either the same firearm or that looks like the firearm. So the state linked that firearm to Mr. Hines on March 21st in order to try to convince the jury that that was the firearm used in these two robberies. In the Hines case in March of 2008, this court said that's improper under the Perkins rule. So I submit that certainly for the 4605 case, it's both factually and procedurally indistinguishable. It's not harmless, and therefore the court should reverse based on the March 2008 Hines case. And again, I would rely upon Burr and Perez for the argument that 294 should also be reversed. Even though the acquittal came after the trial pursuant to Burr and Perez, the Perkins rule applies.
And it's your position that Morris has been overruled?
I think it's distinguishable. I think the 4th DCA and Perez said that Burr silently overruled Morris. I think you could either find that or you could find that it's distinguishable. In Morris, there was a previous trial that resulted in an acquittal, but the acquittal was for murder. And then at the subsequent trial, the state tried to introduce the fact that the defendant during the previous trial, there was evidence that he possessed a particular gun. And that was the fact that they were trying to rely upon during the subsequent case. The jury's verdict in the previous trial had nothing to do with whether or not the defendant possessed the gun. The jury simply found that he didn't commit murder.
Well, the gun was the murder weapon, though, correct?
Oh, but I think the evidence was undisputed that he possessed the gun, and his defense was self-defense, that he'd been attacked and he only used the gun after that. So
the acquittal could have been based on the affirmative defense?
Yes. And either way, the acquittal was as to murder, not possession of the gun, and what the state intended to introduce at the second trial was possession of the gun, not murder. And in fact, in that case, the jury was told that during the previous trial, the defendant was acquitted of murder. So the jury was even given that instruction. Of course, they're not given that instruction in either of these two cases. The state is relying upon the fact that Mr. Hines possessed the firearm on March 21st. During the closing argument in the 4605 case, the state said, and this is on page 305 of the record, he had just hidden the .357 firearm in the grill, and he just went into the apartment. The state is specifically telling the jury that Mr. Hines possessed the firearm on March 21st, and at that point, in the 4605 case, the jury had already determined that he did not possess that firearm.
Mr. Upperman, this may not be in the record, but were there just the three cases, the three armed robbery cases, or are there more in the pipeline, or do we know?
It's not in the record that I'm aware of. I may be aware of another case that's out there.
And the possession of a firearm by a convicted felon charge was tried after 294, but before the others.
The 4605 and before the March 2008 case. That's right.
One might argue that the state simply overcharged this guy.
I would submit that had the state, after obtaining a life sentence in the 294 case, there was no reason for the prosecutor to then pursue the possession of a firearm on March 21st. Why risk letting the jury find that he didn't possess that firearm, especially when the state intended to rely upon that March 21st possession in every single one of these cases? I'll reserve the rest of my time for rebuttal. Thank you.
You have 6.5 minutes left.
Please the court, Thomas Winokur for the appellee, State of Florida. Mr. Ufferman is correct that this court in case number 4305 in March, and actually yesterday denying the motion for a hearing, has in fact determined the issue of whether the collateral crime evidence was inadmissible for the purpose of the subsequent trials, which would include 4305 and 4605, which is this case. So that case, I would agree with Mr. Ufferman that that case is going to apply to 4605 and is going to require reversal on that one. But as Judge Webster suggested, I think a different analysis is going to be necessary for case number 294 for the simple reason that the trial in 294 preceded the trial on the March 21st charge.
Well, the problem with that argument, though, Mr. Winokur, is, and I recognize that you filed this notice of supplemental authority bringing Lane versus State to our attention. The problem with Lane, which is the only Florida case I think that directly supports the State's position in 294, is that it precedes by some 16 years Burr, and that the author of Lane was on the Burr court when it unanimously concluded that under Florida law, the Perkins analysis applies regardless of whether there is a prior or a subsequent acquittal.
I noticed that, Your Honor. Judge Grimes, or Justice Grimes, had written the opinion in the Lane case. But I don't think that Burr can be read as broadly as the appellants wish it to be read, to state a blanket rule that any time that there is a subsequent acquittal of a fact that happened to have been presented in an earlier trial, then that earlier trial has to be reversed. That is a gross overreading of what Burr decided. And in order to demonstrate that, you have to really go back and look at the kind of complex procedural history of Burr. Burr was a capital case, and during the course of the trial, the State introduced evidence of other robberies that Mr. Burr had committed. This was strictly Williams Rule evidence. The evidence was offered solely to demonstrate that he had committed uniquely similar crimes in the past. That was affirmed on appeal, and he then filed a motion for post-conviction relief asserting that he had been acquitted of one of those collateral crimes. The Florida Supreme Court originally said that that subsequent acquittal has no effect on it because we're not going to retroactively exclude evidence from a trial, a principle that the State fully agrees. It went up to the United States Supreme Court, and they asked the Florida Supreme Court to reconsider it in light of Johnson versus Mississippi. In Johnson versus Mississippi, also a capital case, the court had used a conviction from another state as an aggravating, a conviction for a violent crime as an aggravating factor for imposing the death penalty. And the United States Supreme Court in Johnson said that based on the stringent review of death sentences based on improper aggravating circumstances, we're going to reverse because of that subsequent acquittal. So Johnson versus Mississippi was specifically based on the fact that a subsequent acquittal was used in a death case as an aggravator in a death case. That was the specific reason for it. The Florida Supreme Court gets the case back, and they acknowledge that it is substantially different, but say, well, okay, then I guess the subsequent acquittal is going to bar the use of that evidence, but we find it harmless. And it then went back up to the Supreme Court. They asked the Supreme Court again to reconsider it in light of Dowling versus United States. Dowling versus United States was a case that held that the collateral crime rule does not apply to truly Williams Rule evidence, or I guess I should say 404B evidence, because it was a federal case, because the way that that evidence is admitted is you have a pretrial hearing, and the government has to demonstrate by a lower standard, by preponderance of the evidence, that the collateral crime occurred. And because it is a lower standard of evidence, it doesn't bar the introduction of that collateral crime in a subsequent prosecution under the collateral estoppel doctrine. So when the Florida Supreme Court got the case back, they said that, well, we're not going to adopt Dowling because we find that as a matter of state constitutional law, an acquittal for a Williams Rule case bars its use in a subsequent proceeding.
In essence, they decided to give defendants under Florida law more protection than the United States Supreme Court had concluded was appropriate under federal law.
Absolutely. And that's why Perkins is still good law in Florida, even though that rule does not apply in federal courts, and there is no federal constitutional right under collateral estoppel like there is for other forms of evidence. But the key in Burr really is that it was a capital case. The Florida Supreme Court said so in the Burr opinion. It is what the United States Supreme Court based Johnson versus Mississippi on, and it specifically said in discussing Dowling that, well, Dowling wasn't a capital case. So that was one way that they had excluded Dowling. So
was Perkins a capital case?
I thought of that when Mr. Ufferman was up here, and I'm not sure if it was or not.
I don't know.
But again, it was a prior acquittal.
Because what they did in Burr, as you know, is they expressly extended the Perkins holding to the factual situation in Burr. And we can argue about whether they intended to extend it in all criminal cases or whether they intended to limit it to the facts of it being a capital case. But clearly they intended and expressly extended Perkins. And there's no question about that.
They extended Perkins in a very limited way, and sure, we can argue about it.
Maybe.
I intend to argue about it, okay. That Burr, in fact, by its very terms, is limited by the fact that it was a capital case, not to mention the fact that it really was evidence of purely collateral crimes, what I would describe as purely collateral crimes, crimes that are admitted strictly for the purpose of showing similarity between a prior crime and the crime that the defendant committed.
Of course, the problem there is in our previous Hines case, the panel rejected this is not really a collateral crime argument.
Well, that's true, but again, I'm not denying that the 4305 panel is going to apply to the subsequent prosecution.
I understand.
The bottom line, though, is that this is a prior prosecution.
Well, let me ask you, if we were to affirm now in 294, and the defendant, Mr. Hines, filed a 3850, he wins, doesn't he?
I'm not sure if he does or not, Your Honor. Again, you're basing that obviously on the fact that Burr was a 3850 case. And again, I think that Burr could be limited to capital cases. But that actually raises another issue that I wanted to address. One thing about Burr is that this was in fact raised in a 3850 motion. In other words, it was in fact raised before the trial court. Here, in case number 294, this was never raised in the trial court. This did not come up.
Well, and that's why I'm asking you, if he files a 3850 for ineffective assistance of counsel, he gets a new trial, doesn't he?
Well, I'm not sure how it would be ineffective if there was no acquittal in existence at the time.
But if we were going to go your way in 294, what we would say is he can't raise it on direct appeal.
That's correct.
And so he goes and files an ineffective assistance of counsel claim. What choice does the trial court have but to say counsel deprived him of the right to even raise this issue in his previous trial, therefore he's entitled to a new trial where he can raise this issue?
Well, number one, I don't want to quibble with you, but I don't think that counsel could be ineffective for failing to raise an issue that wasn't in existence at the time.
But wouldn't that have to be decided in the collateral proceeding if we went your way?
It would, but then there would be a separate issue as to whether Burr applies to non-capital cases. And not only that, but I still think that Burr can be limited in a couple of other ways. Number one, it was the primary way, other than the fact that it was a capital case, is that it was in fact a purely Williams Rule case. There was in fact a separate, purely collateral crime, and the defendant was acquitted of that purely collateral crime. But I think that it would be very, very bad policy as a general rule to simply say that any time that there's an acquittal, at any point in the future, regarding a fact, not a Williams rule, not Williams rule evidence, but any fact that was introduced in a prior trial, then you're allowed to get relief from that prior ruling is going to be very, very bad public policy.
And of course, we could agree 100% with you on that, but if we conclude that Burr requires that result, it's not public policy we've made.
Well, that's true, but we'll worry about that when we get to the post-conviction proceeding, and we would undoubtedly make the same argument there.
Judge Hawks, by the way, has just pointed out to me that Perkins was a non-capital case.
Thank you, Judge. I thought that it was, but I wasn't certain because it was before the Florida Supreme Court. But I would like to emphasize that in spite of the fact that Perkins is based strictly on state law, as the Florida Supreme Court said in Burr, that the basis of it still is collateral estoppel. If you read Perkins, it does in fact rely on Ash v. Swenson, which was kind of the seminal collateral estoppel case by the United States Supreme Court. And you simply cannot apply collateral estoppel in a way that the appellants are urging us to. Collateral estoppel, by its very nature, is a concept that tells us that when a fact has been determined by a valid and final judgment in a criminal case, it can't be again litigated between the same parties. That's what Ash says. It applies the well-known general rule of fact preclusion or issue preclusion that has been part of our jurisprudence forever. And to turn that around and say that a subsequent proceeding would have the same effect would completely turn that concept on its head.
Except that's precisely what a unanimous Florida Supreme Court did in Burr, at the very least as to the guilt phase of the capital.
They did. They did. But again, if you read Johnson v. Mississippi and you can see their basis for doing it, they really did. It's one of those death is different types of situations. Now, as far as the Perez case goes, I would suggest that Perez overread Burr substantially in saying that it does, in fact, assert a general rule that any kind of subsequent acquittal involving any fact, not just a Williams rule evidence, but any fact, stands to reverse prior litigation. Overreads it, number one. And number two, the Robinson case, which I also supplemented this court with, does in fact say that these types of collateral estoppel issues need to be preserved, like every other issue before an appellate court needs to be preserved if it's not fundamental error. And the collateral estoppel issues need to be preserved. The Perez court sort of skated around that by saying that the state did not object to the supplementation of the record to include the subsequent acquittal. I would suggest that that's a poor substitute for issue preservation. And for that reason, I think that Perez should be rejected, both because it misreads Burr and because it dispenses with issue preservation. Not only that, I think that Perez really was, in fact, a completed crime. It wasn't really Williams rule evidence, but it was a completed crime. Whereas here, in 294, for reasons which aren't clear to me, they did not proceed on the possession of firearm by convicted felon case. So at least with respect to the gun, the fact that Mr. Hines had a gun and hid it in a grill is not a crime. That alone is not a crime. So it's not that the jury, in case number 294 anyway, was informed in any way that Mr. Hines had committed a crime, whereas in Perez there was a threat to police and the threat itself was a crime.
Let me ask you a question about your preservation argument in 294. How would Mr. Hines preserve this issue in the trial court since the acquittal occurred after the trial had been completed?
I think that demonstrates why a subsequent acquittal
certainly it does. Yeah.
Why a subsequent acquittal should not ever be considered a collateral estoppel matter. And probably the correct answer is motion for post-conviction relief. And like I said, we will consider that at the time of whether Burr applies in a motion for post-conviction relief. I see that I'm nearly out of time here, so I would ask this court to affirm Mr. Hines' conviction in case number 294 and to apply case number 4305 to case number 4605.
Thank you, Mr. Winkler. Mr. Efferman.
May it please the court. Two quick points I'd like to make. Number one, I think Lane has only been cited one time by other Florida courts. Lane predates Perkins and Burr, and I think Lane was cited in Perkins as an example of the conflict that existed in Florida, but then in Perkins, the Florida Supreme Court resolved that conflict and came up with the Perkins rule that says if you're acquitted, the state can't rely upon that acquittal in a subsequent trial.
Well, Mr. Offerman, what about Mr. Winkar's argument that because this could not have been preserved in 294 in the trial court, the appropriate place to seek relief would be in a post-conviction proceeding?
I would rely upon Perez, and Perez is identical to this case in that sense. Perez said two things. Number one, it said that Burr applies in non-capital situations. So Perez is applying Burr in a case other than a death penalty case. Number two, Perez applied Burr in a circumstance just like this, where the issue was raised on direct appeal after the trial. The court, through judicial notice or supplementation, recognized that the acquittal occurred in the subsequent case and went ahead and said we're going to apply the Burr rule now, because the Burr rule says that regardless of, under Perkins, regardless of whether the acquittal is before or after the trial, it requires a new trial because the state can't rely upon that particular fact or that particular event at the trial if the jury has acquitted the defendant of that fact or event. So
in order to affirm in 294, we would have to certify conflict with Perez?
Yes, and again, I would argue that at the very least, the court should recognize that the issue could be raised maybe not as an ineffective assistance of counsel claim, but as a newly discovered evidence claim in a 3.850 motion, and pursuant to Burr, Mr. Hines would have to win on that.
Well, can it really be newly discovered evidence if it didn't exist at the time of there was nothing to discover at the time of the trial?
Right. Which I
it's
think
really new evidence.
That's what I'm saying. It would be raised as a new evidence type claim in post-conviction, and pursuant to Burr, he would be entitled to relief. But I submit that the court doesn't need.
But there would be a hearing, and there could be a conclusion that would not be sufficient to grant him relief under the newly discovered evidence parameters. I mean,
I submit
because I'm not as convinced as you sounded that if that was his only avenue that he would obtain relief that way.
I think Burr would require it. I do submit that Burr would require that if he filed a post-conviction motion, he'd be in the identical situation or procedural posture as Burr, and pursuant to Burr, he'd be entitled to relief.
Unless Mr. Winkauer is correct, and Burr is nothing more than a death is different case.
Yes, but then, of course, like you said, the court would have to certify conflict with Perez because Perez applied Burr in a non-capital case. So I would ask this court, I appreciate the state's candor regarding the 4605 case. Obviously, I'd ask that you follow the March 2008 Hines case and reverse in 4605. I'd also ask that you adhere to the Perez case from the 4th District and reverse in the 294 case. Thank you.
Thank you. And Mr. Winkauer, let me say on behalf of the panel, we also appreciate your candor with regard to the 4605 case. We're going to go ahead and take a 15-minute break now. We invite all of you to join us for coffee in the Commons, which is through the doors to your right. We'll be in recess.